Well, hello, everybody, and we're back. My goodness, that didn't take too long. I cannot believe they're wrapping up this trial so fast. I just got an announcement that they're doing closing arguments on day 3. Hello, Bonnie. Hi, Jakey. Hi, Joyce. Hi, Aggie. Hi, Tamara. Hey, Nene. Salem's in here. So the closing arguments have been going on for a while, but I really wanted to catch them with all of you because this case is something else. So I caught part of it this morning, and it was nuts. And we're going to go through it again on Tuesday, but I have a feeling after today we're going to be on verdict watch. I wouldn't be surprised with it being the holiday weekend if they don't have a verdict today. So let's start with closing arguments.
Hey, welcome back. You may call your next witness. All right, ladies and gentlemen, you've heard the defense's case. Any reply by the state?
No, sir.
All right, ladies and gentlemen, you've now heard all of the testimony. You've now received all of the evidence. It's now time for closing arguments. If you will give counsel your attention, first by the state.
Please go ahead.
Yes, sir.
I'm going to talk to you very briefly today about what we know, what evidence we've heard, what testimony you've heard, what you've seen, from everything on the video to the chemical analysis to the experts to everything. What I want to talk about right now is just what we know. There's the question. We start with Christina. Christina was a child born with cerebral palsy. She could not walk. She couldn't grasp. She couldn't talk. She could show emotion, because you've seen, versus this photograph, you can see the child can show emotions, and that's going to be relevant in a few minutes to what I'm talking about. But Christina was not like other girls. She was totally dependent, 100%, on other people. She was dependent on everybody, for somebody to take care of her, somebody to give her food, somebody to give her water, somebody to keep her safe. Christina was totally dependent on Rita to do all of those things. Every day. Every day. Not just on Rita's good days. Not just on days when Rita is posing for photographs. Not just when Rita is sober. But even on the days when Rita chooses to go hang out with Larry and get high on meth. Christina was dependent upon her then too. Totally dependent on her. Even when Rita was high. And you heard testimony from defense witnesses, and they came in and they told you what they did. One had not really had much contact with her for 18 years, except through Facebook. Her daughter came in and said what a daughter should say. She's a good mother. But neither one of them knew about the meth. Neither one of them. And we know on that day, where none of those witnesses were, they didn't know what was going on. On that day, on that weekend, on that Friday, that Saturday, the Sunday, and the Monday, we know that they were on a meth bender. We know it because we took their blood. You know it because you had chemists, 1, 2, 3 chemists come in and tell you that. Methamphetamine in both Rita's blood as well as Larry, and all well over the limit that would make them high. And if you didn't, for whatever reason, think that was enough, Larry told you the same thing. He didn't want to, but he did. He hadn't slept in 3 days. He and Rita had been doing meth. She liked to put it in her coffee. He didn't want to tell us, but he did. And we know that. That little girl was dependent upon Rita to take care of her, to keep her safe. Rita was high. Neither her daughter knew about that, or the other lady that testified. But we know that. Not any shadow of a doubt. What else do we know? We know that Larry had first of all, we know that in the middle of that vendor, Rita and Larry get in Larry's truck and go get the child and bring her into that environment where they're getting high. And they go in and they stay the night. And we now know that Larry had a security system, a very good one, a very sensitive one, that would pick up any type of motion going in and around the car. And we know, because there's direct testimony, that there was no motion around that car at all until 11:15. And 11:15, the motion we saw with these two going to the car. So what do we know? The car's not on. There's no air conditioning. Nobody's been near that car. Unless the angle was that they parked the night before and left the car running with the air conditioning on. But nobody said that. Larry said, oh, the car was running when we put the child in. Because Larry needed to say the car was running when we put the child in. Not because it was true. And you know, because you could see it. The car went on. There wasn't air conditioning. And they left the child in that car for 1 hour and 15 minutes before there was any more motion, before there was any more interaction with that car. We know because of, lift these back around. We know that as about 11 o'clock is when, about 12 o'clock is when the heat starts spiking inside the car. We know that because we actually brought an expert, Dr. Grunstein, to come testify to you about what happens inside the car when it's that hot outside in August in South Carolina. And this spike starts right after 12 o'clock. Until then, it's about the same as the car. So you're talking about 90, 80, 90 degrees to begin with. And by the time they go back to that car at 12:15, Larry doesn't go back to the car, but Rita does. We're already over here. The heat inside that car is now approaching 100 degrees. Now I want to go back to this. And first of all, let me just stop this here. If all they had done was put that child in a hot car in the middle of August and left that child there for an hour and 15 minutes, in some way, miraculously, somebody had come along and gotten that child out, I submit to you they still would have inflicted serious bodily injury on that child, because the definition of serious bodily injury is a likelihood that it could cause serious impairment or death. And I don't think there's any question at all what the end of this result was. If we stop there, you have that. And did they do it together? Absolutely. Even Larry testified to that. We did everything together. Put them in the car together, and you see that? We left them in the car together. And there's your conspiracy. That's not all we have. Unfortunately, it didn't stop there. Unfortunately, the child was not rescued from the people that she depended on or anybody else. So now we're at 12:15. Child has been in the 12:30, excuse me, child's been down in the car for an hour and 15 minutes. No air, no wind, not even a crack window. Now, Rita goes back to the car. She opens both doors. She opened both doors, the air conditioning's on. She opened both doors, maybe let a little wind out of there, which is the only considerate thing she did in this entire room. Do you know what else she did? She looked inside the car. And now I want you to think about something. Go back to Christine's picture. This child can show emotion. She can't scream and she can't talk, but she can show emotion. You can see it in her face. So what did she look like when her mother was looking at her after being left in a hot car by herself with no wind in 100-degree heat for an hour and 15 minutes? You read to see when she looks at the car. Child's got to be going, oh, that's not a happy face in the car. After an hour and 15 minutes of this heat in that car by herself, a child who's totally dependent on others, she's begging for help. So what does Rita do? She closes the door. She goes back inside with Larry. The first time, she and Larry put the child in the car. And they go inside, as Larry says, to make up, to have sex. So while they're inside having sex, the child is out in the car. She comes back out, looks at the child. The child at this point had to be begging. She closes the door and goes back inside to spend some more time with Larry. Which, by the way, will be the last time anyone approaches that car to look after that girl until 3 o'clock in the afternoon. They go back on the porch. Not this one. They go back on the porch about an hour and a half later. They don't actually walk out into the car. They don't go see the car. It's been another hour and 15 minutes. They go back out on the porch. They hang out on the porch. And now it's 2 o'clock, 2:02 to be exact. Neither one of them approached the car. The girl is still in there. And what's going on inside the car now? Now it's 2 o'clock. 11, 12, 1, 2. Take a look at the temperature inside that car now. It's now reached that maximum temperature. It's getting closer to that maximum temperature. It's well over 110, 115 degrees inside that car. And they come back out. And do they go check on it? No. What do they do? They hug. They kiss. And then they go back inside for another hour and 15 minutes. The child is literally cooking to death in the car, and they're going back inside again. And they stay in there for an hour and 15 minutes. And then they come back out. This time, Rita actually walks to the car. This is when she finds that the keys are locked in the car. But pay very close attention to this. Where does Rita walk when she walks out of the house? It's now 3 o'clock. The child has been in the car since 11:15. The heat is now at well over 118 degrees. Inside the car, it feels like 135 degrees. You've heard testimony from experts giving you that testimony. And where does Rita go? Does she go to the side the child's on to check on her? Is she trying to get in the car to drive? No. What's she doing? She's going to get her cigarettes. In the back seat of the car, where they put this child at 11:15, there was a bag in the back seat. Right beside the child. And inside that bag was this. A gun.
Renewed objection.
And not only
401, 403.
May proceed.
And not only was it a gun, it was a loaded gun.
It's overruled.
Again, in a bag, right beside this child. And right there, also, are the cigarettes. She walks back out to the car at 3 o'clock. She's still not going to check on the child. even going to drive away. She's going to get some cigarettes. And she finds that the car is locked. So what do they do? The car is locked. The child has been in the car since 11:15. It is now 3 o'clock in the afternoon. It is well over 118 degrees inside that car. It feels like 135. They have found that the keys are locked in the car. So what do? Naturally, they break the window. No, they don't. Because since it's too expensive, so break the window.
Objection, yesterday, if it's not vaccinated.
Let's go.
Your Honor, it was sustained.
Objection is overruled.
Thank you, Your Honor. Break the window? Now. What do? They hang out. They get on the swing and start swinging back and forth. It's now 3:19. 19 minutes after they found that the child is locked in the car with the keys. 19 minutes after we know for a fact it's already 118 degrees inside the car. And what are they doing? They're swinging. Is there any sense of urgency here? Is at any point in time they're going to say, hey, we need to take care of this child? No, we're swinging. And then what do? They eventually go to Larry's truck, which is parked out back. And now what do? It is now 39 minutes later. It is 3:39. They're still at the house. And they're kissing. They're not taking care of the child. They're not thinking about the child. They're thinking about themselves. So then let's go get a spare key. This is where the child is. And this is where Larry and Rita go to go get a spare key, which is why they don't get back for 52 minutes. The child's locked in the car at 3 o'clock. They don't get back until 4. Any sense of urgency there? Any concern for the health and welfare of that child? Did the child even cross their minds? Because they were high. And they were interested in each other. And they were interested in kissing, and hugging, and spending time with each other, and having sex. Even the doctor talked about the increased libido as a result of being high on that. And you see it in all these pictures, because that's what they're concerned about. Not an ounce of concern for that child. 52 minutes. And then when they get back, they arrive 4:40. They get back to the house at 4:40. They're in Larry's truck. Thank goodness they've got a key. They can come rescue this child now. When did they get out of the truck? They don't open the door till 4:44. They sit in the truck for 4 minutes and talking and hanging out. Again, no concern for the child whatsoever. They're just hanging out in the truck. And eventually they get out. And they approach the car. And when they do, neither one of them are sober enough to even figure out how to unlock the car. Larry testified, I'm not pushing the unlock button, but it's not unlocking. It's because he's locking it. He's locking it, he's unlocking, he's pushing it. And the testimony that you heard from Captain Chapman, but also from even Larry, pushing the button, and the light's coming on when I'm pushing the button, but it's not unlocking. And what you know is that when it's hit the emergency flasher, it's going flash, flash, flash. But at the end, when it goes blink, 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 that's hitting the lock and the unlock. I think it's once for lock, maybe 2 for unlock, I don't know. But the point is that you can't do that if the car's on. But we already do that. You know how you know that? Because otherwise, if you spend 5 hours in the car in South Carolina driving around with your air conditioning on, we would all be dead. Clearly, the air conditioning wasn't on. They may have thought it was, but clearly the car wasn't on, the air conditioning wasn't on. And why do we know that? Because the child cooked to death. That's why. And I'll say something else. Not one piece of testimony, not one person, not one, any of you said, I turned the car on. Larry said, I was already on when I put the child in there. Although we know that's not true. Did Larry say he turned the car on? Nope. What did Larry say? I turned the car off. And we'll get to that in just a second. So they get the child and they pull the child out of the car. What happens then? Oh, and by the way, one other thing too, they haven't gotten the child out of the car yet. They can't figure out how to unlock it. It's now 4:47, and they're back to hugging again. That's not a distraught picture because they haven't pulled the child out of the car yet. They're still hugging and kissing. They still haven't focused on the child. And eventually, we get the child out of the car. What happens after that? They pull the child up. They pull the child out. Larry calls 911. What does Rita do? She leaves. When Hallie Godley gets there, Rita's nowhere to be found. She's inside the house. And that's particularly relevant for what we're going to talk about in just a second. He calls 911, but before the police get there, what does he say? I reached in and turned the car off. How did you do that? Think about it a minute. They just pulled a dead child out of the car. He's calling 911. Police are on the way. Why does he reach in the car and turn it off? Don't want to waste gas? What? Why would you in any way, shape, or form stop what you're doing when there is a dead child on the ground to go reach in and turn the car off? You wouldn't. There's no reason for that. But there's a real good reason to reach inside that car and turn it on. And what you heard Captain Chapman say today is, when we got there, the car was running. The air conditioner was working just like it was working 3 days ago. There was no compression issue with that car, compressor issue with that car. It works. And the air was on, the car was running, but it wasn't cold inside. The air conditioner was blowing cold, but it wasn't cold inside that car. Why? Because Larry had just turned it on right before the police got there. Why? Because he knew he just murdered that child. That's why. And by the way, what did Rita say when they finally went and got Rita out of the house and brought her out? What did she say? Hallie Godley testified to this Monday. That was the very first witness. She said, I brought Rita out, and Rita said, we put the child in the car. I went inside to get cigarettes. I came back out, and the car was locked. That was her description of what happened. Even Rita didn't say the car was on with the air conditioner running. Because that would have been the very first thing out of her mouth if that was true. Instead, it was, it was just a matter of seconds. I went inside to get cigarettes. I came back out, and the car was locked. That was it. Because Rita didn't know they had the camera system. Thank goodness they did. Because we wouldn't know any better. But we do know better. The child wasn't just in the car for a split second. The child was in the car for 5 hours and 42 minutes. It's an awfully long time. Everything I have told you so far, you know. No issue about it, just know. I think you've heard about that. So you know what happened. The question is before you now is, what do you call it? What is it? You know what it is. You've seen it. You've heard the testimony. The question is, what do you call it? Putting that child in the car to begin with, and leaving that child in the car, exposing that child to potential death, was the infliction of injury to that child, rose to the level of substantial death. The first charge, they did that early. The conspiracy, they did everything together. But the rest of the 4 hours, the child was in the car. What about the pain and suffering that that child had to endure before they died, as Dr. Vitalis testified to you? We expect at 105 degrees that people start dying. We've all had fevers. You know how bad you feel at 100-degree fever or 101. Child's inside temperature was 110. And Dr. Vitalis said, I'll be honest with you, I think at 104, 105, the brain stops working, the organs start shutting down. She vomited into her throat. She defecated in her diaper. You see that in the crime scene pictures. Her whole body just stopped working. And I'll be honest with you, I wouldn't expect her to last more than an hour in those conditions. They put her in those conditions for 5 hours before the sequence. So we know about the infliction of serious bodily injury. We know about the conspiracy. What do you call the child's death? Well, murder is the unlawful killing of another with malice. What does that mean? Unlawful killing of another, that's pretty easy, but what's malice? Well, there are 2 ways to show malice. One is expressed. If you walk up to somebody and say, I hate you, I'm going to kill you, I don't care if you live or die, you shoot them in the head, that's express malice. This case is about implied malice. And what is implied malice? Implied malice is that you can take from the facts and circumstances of the case, what you have seen, what you have heard, what you know about this case, that someone was so extremely reckless that they had a wanton disregard for human life. They may not even have direct ill feelings toward that one individual, but their attitude, their actions, all of the things that they chose to do, all the way they chose to act, all led back to conscious disregard for the lives of others, and in this case, the other person was Christina, a child totally dependent on them for safety. A wickedness, a depravity, malicious. And we know what malicious is. And so I ask you as you go back and look at all of this, at what point in time in any of this did either one of these 2 people show an ounce of compassion or care or concern for Christina's life? If they had walked up to her and shot her, she wouldn't have suffered the pain that she suffered in this case.
Objection, Your Honor, an inflammatory matter of law is appropriate.
Objection's overruled.
Thank you, Your Honor. 5 hours and 42 minutes of suffering. You see the blisters on her legs, the burn marks from her coming in contact with other parts of that car that was also rose to a level of 118 degrees or 135. She was burned externally and internally. What do you call it? Well, I'll tell you that if you're sitting around talking to your family members or your friends and you're describing this situation to them, you may not talk in terms of legal anything. But I think a good way to describe this is torture. The child was tortured. Before Larry and Rita, after Larry and Rita. Not the Larry and Rita that these other people didn't know. The Larry and Rita that were high on meth. And these bruises and these blisters that Dr. Vitalis described, torture. And you don't accidentally torture somebody. You treat them with such a lack of disregard for their human life that they die because of the torture. And that's what happened in this case. In the real world, you're talking to fans and family, and you're describing all of this. You might use the word torture. in this courtroom today and ask you to use the word murder. Thank you.
Boy, yes, sir.
Thank you, Your Honor. Good afternoon. Good afternoon. Solicitor, in his comments to you, said a bunch of stuff, and some of it I agree with, some of it I don't. I'd like to remind you at the outset that a moment ago, in the midst of his remarks, what he said was, and I wrote it down, they may have thought that the air conditioner was on. That's what he said. I will tell you right now, when you have heard the judge explain the law in this case, and you apply it to the facts that you've heard here, that sentence alone means the murder goes out the window. We'll talk about murder in a minute, but please, if you think nothing else about that opening remark, remember that the solicitor has conceded to you that Mr. King may well have thought that the air conditioner was on in that car. Now, ladies and gentlemen, I'm here on behalf of Mr. King. My remarks to you were addressed solely as relates to Mr. King. Ms. Pangalangan has a really good attorney, smart guy. He's going to address you soon as relates to her. So again, understand, I'm not talking about the two of them. We're talking about Mr. King. Another thing that the solicitor pointed out in his opening remarks that I agree with was he said, well, this child was totally dependent upon reading. And he said it over and over, and it's because it's true. This was a child who was always going to be dependent on her mother. Her mother was responsible for her. Her mother had to care of her. Her mother may well have tried to do the best she could or not. I'm not talking about her, but I'm talking about the child who was completely in her care. There's no evidence before you that Mr. King was this child's father, Mr. King had adopted this child, that Mr. King and Miss Rita were married, and he was some sort of step-parent. He was dating her mom. It doesn't create some sort of legal bond between them or create duties that he has to do. This child is in the care of her mother, and he's visiting with her mother on that particular day. Ladies and gentlemen, when y'all return to the jury, when the judge is charged you on the law and suggests or instructed that you commence or begin your deliberations, it may be that if y'all read Mr. King's indictments first, they can simply say, looking at the laws the judge gives it to you, Larry is not guilty of the crime. At least he's not guilty of any one of these crimes alleged in this indictment. Larry didn't kill anybody. He didn't commit a murder. He didn't cause grief bodily injury to anybody. And I'll talk about the conspiracy before. There's going to be no evidence to support that. It may be that at the outset you say, I understand why this thing's outrageous. This never should have happened the way that it did. But Mr. King didn't kill him. If that's the case, I don't know if we have a full person. But if that's the case, whoever the full person is on the jury, you fully entitled to this right to not guilty. Set those indictments aside and move on with whatever other business y'all have. But in the event that one or more of you feel like his circumstantial situation merits further discussion in the jury or deliberation, I need to talk to you about a few more things, okay? First of all, the judge is going to tell you soon that every person charged with a crime is presumed innocent of any wrongdoing. And I know they might wrote a book and they made a movie called Presumed Innocent and stuff like that, but it's an absolutely critical term of law when used in court here today. And what it means is the defendant, although he chose to testify, has absolutely nothing to prove during the course of the prosecution or during the course of his defense. And you hear you have a right to remain silent, and that right cannot be used against you if you choose to exercise it. It's because of the presumption of innocence. It doesn't mean you'll wait and see. maybe, maybe not. Show me what you got. It means at the outset of the trial, even to this point, look at that paper, and you say he's innocent. And then you look at this table, and you say, okay, Mr. Solicitor, your office brought the indictment, your office called the case, your office summons law reports, I'm here to try the case, you schedule. Prove to me that the defendant is guilty of the crimes in this indictment or in these indictments. And for the state to prevail, to meet that burden, what it means is they have to prove every element, ingredient, element, they have to prove every element of the crimes that are alleged within the indictment. They have to prove them beyond a reasonable doubt. So this isn't civil court. I don't know if you've done that. Sometimes you see the statute, letting the justice, when he's holding the scale, and it tips a little. In civil court, it's preponderance of the evidence. It tips one way or the other, that side of things. It's not that way here. Today, it's proof beyond a reasonable doubt. The state called a murder indictment against Mr. King, alleging that he had murdered a child. It means they make you promise as jurors that they will dispel every reasonable doubt, every element, and prove beyond hesitation that Mr. King is a murderer and that he murdered that child. I'm talking about beyond a reasonable doubt. This term of art also is because his honor is going to define it. But a reasonable doubt, and he will tell you, I know you all pay attention to the charges, he can tell you that a reasonable doubt is the kind of doubt that would cause a person to hesitate to act in the course of their own most important affairs. And in any criminal trial, if your juror has that kind of a doubt as to the guilt of the defendant, you are required by the oath that you took earlier to return the verdict not. So, if we put aside some of what I would call the clutter or distraction in this case, and just look at what is actually relevant and what should help you in your search for the truth or in your weighing of the evidence that's been presented before you, I would suggest to you that most of what you've seen is more or less clutter, okay? I mean, the state called Dr. Grundy here. The state called an expert from Georgia. He was an expert in heat. And he came from Georgia to tell y'all something that every one of you already knows. If you park a car in the direct sunlight in eastern South Carolina in August, with no air conditioner and the engine not running, it's going to get too hot to live in that car. So the charts and his testimony and all this, it's filler. Because it doesn't give you a chance to look in Mr. King's heart, which is what you're going to have to do shortly. We conceded in our opening statement that this child was in a car, that it got too hot, and she died. Submit to you that this professor from Georgia doesn't really bring anything new to the table. You can pretty much set it aside because we know what happened. It got too hot in the car and the child died. The pathologist is the same. You already knew before the pathologist ever took the witness stand what had happened with this child. You had heard us concede that this is what happened, you had seen the videotape that this is what happened, and you knew this child died from me. Really nothing is useful to you whatsoever. They called this police officer, Captain So-and-so, and I don't know why he's back up here today. But they called him to testify to this key fob. There's been a lot of talk back and forth. But really, what was necessary to hear from him was plain and simple. It came out yesterday. He said, if you unlock the car, or you lock the car, while the engine's running, the lights don't flash. Nobody ever locked or unlocked the car with a key fob that they retrieved from Reed's house. Because as you heard, the battery was dying. Once or twice they hit the key fob, the doors didn't unlock, the lights flickered, and then they didn't flicker anymore. So, fine. You lock it or you unlock it while the engine's running with the key fob, the lights don't flash. It never happened. It's irrelevant to this case. And as much as the solicitor wants to talk about methamphetamine in this case, because it's presentation when it's bad, and people think terrible stuff, because it is a terrible stuff. Much as he wants to talk about that, they're not charged with methamphetamine. And when the solicitor says the only reason that you know methamphetamine was involved in this case is because their expert came to testify to that, I submit to you that's not true. As a matter of fact, what their witness did to the toxicologist, while I submit she gave you nothing that would help you inside of this case. She said methamphetamine goes to the cycle, you take it in, it peaks in your bloodstream, body processes, it goes out of your bloodstream. She says, yes, people get a tolerance to it, and I would submit to you that if anybody would have a tolerance to it based on all the evidence that you know, it's probably. She also said that, yeah, Mr. King having 400, that was certainly a level to raise eyebrows or cause concern, but that she's seen it up to 2,000. This doesn't have anything to do with the charge of murder. We don't talk about that. But what she did do was give the defense, wrapped up in a nice box with a fancy bow, a gift to Mr. King. Because she said on the witness stand, under some fairly strict cross-examination by Mr. Phillips, yes, this stuff can take up to 3 days to get out of your body. She further confirmed to him, I can't say if this is from ingesting methamphetamine that day or the night before, or if it's from 3 days before. I simply can't say that. You know, as bureaus, that there's a whole lot of people who would have sat at the defense table. That would have been the story. I took it 3 days ago, and I get on the stand. Only the second time I ever used it. 3 days before that, 2 days before that. I was just tired. That was the only effect I was under. I was outnumbered this time. Mr. King got to the stand, and he rejected that. He took an oath to tell you the truth. And where it hurt him, potentially, or at least make the solicitor realize he has been smoking right in the he told her. No one else was going to tell you he was addicted to methamphetamine. No one else is going to tell you he was what's called a functional addict. That is, that he used methamphetamine throughout the day to allow him to function. Never been without work, so I excuse him. Had 5 jobs in his life, so I excuse him. He's always been functioning, going to work, supporting himself, meeting his needs. But just as they're all functional alcoholics, he was a functional addict. No one else was going to tell you. The solicitor knows that, right? And he's probably going to talk about it some more because he loves talking about that. Why did he tell you that? Because he tells the truth. Good, bad, let the chips fall where they may. This is what happened. It's not that he didn't want you to know it's a solicitor. The only time he hesitated to answer was when he asked about me. And according to his own code, he said, I'll speak for myself. And he answered the question. But the judge will soon tell you that it's up to you as jurors to judge the credibility of the witnesses as they come in here to testify. And credibility means the believability. And there's no magic formula for it, but the judge will tell you it's your own opinion based on your own experience, your own worldview. But when a person testifies, you can see that they testify consistently or inconsistently, they testify contradict themselves, or they supported by other facts and evidence, or other evidence that's being presented. And I will submit to you that if Mr. King will come in and give the state this gift, knowing full well it sounds bad, but he's honest enough to give you that, you can certainly find he's honest enough to give you the rest. If he'll tell you the things that are bad for him and you believe him, you can probably believe him when he tells you the rest of it also. Now, the state has charged Mr. King with murder. I assume it's the worst crime there is. The murder murder is not hard to define. Murder is the killing of a human being with malice aforethought. First of all, as relates to Larry's case, the murder indictment fails immediately. Okay? Larry didn't kill anybody. If you recall, when you think back to the solicitor's opening argument, or opening statement, his opening statement, he says that he's going to show you the videotape where Mr. King rudely comes down with this child, the doors open, he throws the child in like so much baggage, but he just wants to be rid of her, and he uses the term 2 or 3 more times. She was just baggage. I know y'all want to take my side of my lawyers can't help it. We watch y'all break it up. I watch y'all on this one. I know everybody paid attention. Everybody listened to all the evidence. On behalf of Mr. King, thank you all for that. But you didn't see that. What you saw, it's in evidence. You see it again if you need to. Was Mr. King come out, as he described, appropriately, properly, gently, maybe lovingly, but certainly appropriately, properly, gently, appropriately. Place the child in the back seat. Move the child, put her in the proper position when you come. Step back. Rita stepped up, put the seatbelt on her, and she did what she needed to do to have the child settled. That's all Larry did in this case. That is the sum total of what he did. He relinquished this child into the arms of her mother. He stepped away. I got feelings hurt. Heartbroken way he described it. I'm out, and he tells her to go. You just go. Leave. I'll talk to you later. She doesn't leave, obviously. She goes back and forth. But at that point, the solicitor would need to prove to you, hold on, that when Larry King put her in that car, he did it with malice. First of all, he's got to prove that putting her in the car, killing her, which of course is nonsense. It didn't. He made efforts to make sure she was safe and well done, properly positioned in there. And then he's got to show that when Larry did that, when he put that child in that car, he did it with malice. That he killed her, and he did it with malice. What does malice mean? I'm going to read it to you. Sorry, I'm going to read it. Malice is hate, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstance in which the law will confer an evil intent. That's what malice is. So before you can even consider whether or not Mr. King should be convicted of murder, you have to consider whether or not there's any evidence whatsoever that you believe he put that child in that car with hatred, ill will, hostility, or the intention of doing a wrongful act. And that's nonsense. And y'all met Mr. King. Y'all met him. Y'all have a chance to judge his credibility, his believability, and to determine whether or not you think he's the man, based on everything you heard, everything you saw, whether or not the state has proof beyond any reasonable doubt in your mind that when he put the child in the car, he did it with hate, ill will, and malice. And it's nonsense. Further, malice can mean a general malignant recklessness for the lives and safety of the others, or a condition of mind that shows a heart, regardless of social duty, and fatally bent on mischief. And all of that's real strong language, and there's a reason for that. It's because it needs to be. It's the worst crime that there is. And if Larry actually walked out and put the child in the car with the intention of the mom driving her safely away, and then he stepped away and said, y'all go, and he doesn't do anything else to this family, there's no indication whatsoever of malice, hatred, or guilt. And without the murder indictment falls. It falls for element one, killing someone, and it falls for malice, because he didn't kill anybody, and there's no indication he had any malicious, ill will, ill intent toward this child. That's what the state promised to do. Ladies and gentlemen, in in your jury room, excuse me, in your jury room, you will have the indictments, and there are 3 indictments Mr. King is called to answer to. Murder, and I've addressed that. Inflicting great bodily injury on a child, and the arguments of this. And a conspiracy charge. When you have those indictments in your jury room, you are fully entitled to look at them, examine them, and see what you think about those documents. You may notice, if you look closely, that shortly after this child died, Mr. King was indicted for murder. Period. Stop. And then as time went on, and a trial went, and the rubber's going to meet the road, we're going to put it to the test. Somebody looked at that murder indictment and said, this is a lie. It was 2.5, maybe 3 years later, coming in for the trial, they came up with new charges. And that's just, look at the dates. Look at the dates. They got all this fire in their heart, absolute confidence in this murder case, we proved that, etc. Why are you coming around at the back end and trying to get a fallback position? You know why. It's because there's no evidence of malice whatsoever. There's no evidence. That indictment goes by the wayside. The arguments as to inflicting great bodily injury upon this child are the same. Mr. King placed the child in the car. At that point, she's not in his house, she's in the car. Mom can get in the car and drive away. Mom can get in the car and drive 100 miles an hour. Mom can go to walk. She can do whatever she wants to do. She's not his child. He is not responsible for this child. He is not the one who needs to take care of this child. He steps away and says, y'all just go. She's off this plane, so to speak. He didn't hurt her. He didn't cause her to be hurt. As a matter of fact, as the solicitor concedes, he thought the engine was running, the air conditioning was going, and she was off the plane. He'd seen nothing in the previous background causing concern that she wasn't able to care for her child, or in some way she was going to allow the child to hurt, or that the child was in danger because her mother was sick. And her mother had. And as the solicitor states, she'd always ride on the reader. And I'm not sure you could read it. That's a different, not on my plate, but she relied on the reader. Only one person was responsible for the child that day. And it wasn't Mr. King. Now, that would bring us to the conspiracy charge. Mr. King is also charged with conspiracy. I told you at the outset, admonished for it. I don't know what the conspiracy to do with it. And like it doesn't say. It doesn't say conspiracy to commit murder, conspiracy to cause great bodily injury to this guy, but a conspiracy. Okay. I'll assume, or I'll go with, that means he must have conspired, because the solicitor made a point of saying how they acted together, everything they did together. Well, he must have conspired to murder this child. Or he must have conspired to cause great bodily injury to this child. I'll tell you what conspiracy means. His Honor is going to tell you shortly, but just so I don't get it wrong. Conspiracy is defined as the combination between 2 or more persons for the purpose of accomplishing a criminal or unlawful object, or an object either criminal or unlawful or by law. So basically it means conspiracy is defined as the combination between 2 or more persons for the purpose of accomplishing a criminal act. So he's alleging that Mr. King has conspired with someone to murder this guy. Now, if you look up the word purpose, Google it, it'll tell you it means intention. The judge's purpose here today is to rule on matters of law and ensure that defendants get a fair trial. The judge's intention here today is to rule on matters of law and ensure that the defendants get a fair trial. So, we can substitute that word and say a combination between 2 or more persons with the intention of accomplishing a criminal act. So, I told you at the outset this was a garbage indictment, it is. Certainly, even the state is not going to get up here and tell you that they've established evidence that shows Mr. King and Ms. Pangalangan somehow got together and decided, how are we going to murder this child? How are we going to hurt this child? How will we kill this child to death? The law says that they come together for the purpose or with the intention of accomplishing a crime. And it's absolutely devoid of any evidence that shows Mr. King ever intended to commit a crime. I'm almost done. But let me do this, and then I'll sit down. Let me do this. Take you back to this tape and consider it this way. Blank slate. You watch this tape, and Mr. King walks out with his child in his arms. He places the child in the car. He steps back. Stay with me. He has a conversation with Freedom. You need to go, etc. And then he turns around, he goes to the back of his house, he drives away. He's upset, he goes to his brother's house, he goes wherever he wants, he turns and he drives away. And then the events unfold exactly as they did here, without him being at his house. Is there any way he's committed a crime? Is there any way he exhibited malevolence, ill will, or hatred? Is there any way whatsoever? And the only answer is no. Well, the only difference between the scenario I just described and what took place is that in this case, he was present in the case. He didn't do anything different. He was just present. His honor was soon telling him that you cannot be guilty of a crime created by the presence. And Mr. King's undying regret already until he dies. He was present with a crime, but he all determined. But he did no more in reality than he did in the scenario I just described. Thank you.
Ladies and gentlemen, we're going to break for 45 minutes for lunch. Please do not discuss the case if you will go to the jury room. Mr. Phillips.
Thank you, Your Honor. As a parent, this case is hard for me. I have 3 little children, and I know it's hard for you. I said it in opening. The raw emotion that you feel, I'll be candid. I'll put my cards on the table. It's anger. I can't watch the video and not yell, please break the window. It's anger. I have to be candid with it. And I know you feel the same. I told you that in opening. I'm not running from it. This case is what it is. There's the video. But after reviewing what we have of the evidence and the video itself, this case is a lottery, but it's not murder. When you separate that, my job is much easier than yours. I'm an advocate. Your job you've taken a sworn oath before God to separate that. And that's hard. That's not something normal people have to do. You have to separate emotion. You'll hear from the judge and instruct you on the law that passion, prejudice, hatred, any of that stuff that comes up in this trial, those raw emotions, you have to set that aside. And you have to base your verdict solely on the evidence that's presented on that witness stand and admitted through everything that we see. But when we do that, it's not murder. It's a lot of things, but it's not murder. You swore to give her a fair trial and not base your decision on emotion. Now, I give you every right, because it's natural, it's human nature. In this courtroom right here, you can be as angry as you want to be. You can be angry, you can have those natural feelings. We all know it's natural. However, and I can't stress this enough, when you cross the threshold of that door and walk in that jury room, you have a sworn oath that you are separating yourself from that. Your job is hard. But you took that oath, and you have an incredible responsibility. That when you cross that threshold, you have to separate that and apply just the law. And again, I'm not saying it's easy. It's not easy for me. But we've all seen it. And in this case, the government's done a lot of different things, and we'll touch on that. But I just can't stress it enough. I have to say it again. Be angry now. Have that emotion. But you can't let it cross that threshold and go into that jury room. You swore not to do that. And if somebody in that jury room starts talking about that kind of stuff, or starts talking about TVs and all this other stuff that's improper, I empower each of you to come tell the judge, because that is not what's supposed to happen. That is not the law. We're going to follow the law in this courthouse. And it's not easy. It's not easy. But that is the law, and that is your sworn duty. Now, depraved heart murder, this malice, this extreme reckless disregard for human life. The government went painstakingly to say, well, that's easy. Well, let's walk through that. Today, I showed you on this Defense Exhibit 15 that's been admitted, they put an officer on that stand the first day. He was unequivocal that the lights won't flash if that car's running. Turns out he was there and it can flash. And he can come up with any explanation he wants. But the facts are the facts, and the video's the video, just like the video you gotta watch. It's tough. And they gotta own this video just like we gotta own that video. They can't run from it. And I want you, if you have any questions about it, watch it for yourself. It's short, and it shows what he said and what was unequivocal, and what they would have argued if I didn't do that. They would have said there's no way that car was running. And then you hear for the first time today from him that the car was running when he got there. You didn't hear that from Ms. Godley, that first witness. You didn't hear that from him until now when he's backtracking. Why? They want that murder conviction so bad. They got the cameras. This is their spotlight. They're going to make the news. They're going to send a message, right? That's not your job. Your job's not to get caught in that. You leave that anger in this courtroom, and you decide this case on the law. In that. Now, we see Rita go to the car at, they said 12:15, I think it's 12:29, but again, you have all the time in the world, and it's your show once you get the case. You can watch the video as many times as you want. You can go through any parts. I empower you. If you're not sure what somebody said, Madam Court Reporter can pull it up for you. We're not running from the facts of this case. They are what they are. But Rita goes to that car, and there's only 3 scenarios. And they intentionally, I think, left this out, and I'll just say it. They said, well, she opens both doors. Right before that, again, what does she do? She comes out, she opens the front door. She sits in that car. And we know she sits in the front door for a period of time because the camera skips. That means there wasn't motion. So we know she sat in the front seat of the car. There's only 3 scenarios. She sat in the front seat for a period of time, and the car wasn't running, and she left it that way. I submit to you, that's a depraved heart murder. If they both believed that car wasn't running and the air conditioner wasn't on, they're right. That's depraved heart. But the solicitor conceded that they might have believed that the air conditioner was running. But we also got testimony today that the car was running. She didn't hear the day before. That's strange. They then tried to flip it that Larry turned it off, or turned the car on right beforehand. We heard this extra testimony from Officer Chapman. Again, you watch the video, anybody that does a push button start a car, you got to push in the brake to cut the car engine on. Guess what he doesn't do? He doesn't sit in that car and push it. He doesn't leans in and hits the button. Why would they do that? Also says, Rita doesn't know they have a surveillance camera. Their own evidence shows that in his bedroom, where they say for hours is what they contend, there's the surveillance camera videos. This is their evidence. This is what they brought. And he's switching it up in closing, saying she doesn't know anything about it. Also their evidence. The surveillance camera itself, sitting right behind the swing. Rita doesn't know there's a surveillance camera. That's the solicitor's words. He's going to have to own this. They want this conviction back. They want you to use emotion. They want you to be angry. That's not what you're going to do. I know you're not. We chose you all for a reason. Because you swore to do that and follow the law. The facts are the facts. They can't run from them. They try to show this gun. Where's that picture of the gun? The gun had nothing to do with this case. They truly believed it was a murder based on the facts they presented. Why are they trying to show something on it? It shows the weakness of their case. They're just trying to inflame you and get you more angry. What's the purpose of the gun? Now, my position is this. They knew they had a problem, and 3 years later, they did the infliction of great bodily injury because they knew they had a problem with proven murder. Why else add that charge? This case is a lot of things, but it's not murder. They knew that, and that's why they added that indictment. Now, you'll hear that reasonable doubt is kind of defined in 2 ways. That you're firmly convinced of something, or it's something that causes you a hesitation to act. And that's important because I like to describe, defense lawyers have a hard time trying to always come up with a way to describe legal definitions. But this is how I like to do reasonable doubt. I say you consider it a voting booth, very similar to going back to a jury room. You got to make a decision. You got 2 options, not guilty and guilty. Under the law, Rita is presumed innocent. That not guilty button is already pushed. Now the state has to prove beyond a reasonable doubt all the elements, malice, this depraved heart, based on the evidence, that you don't have any hesitation to hit that guilty button. If you have any hesitation, you'll hear the judge himself tell you, if you have any hesitation, that's a reasonable doubt in the law. She's not guilty of murder. If you're firmly convinced, no hesitation, you're 100% sold, there's no doubt that they thought that car was running an AC, that's a brake part. We own that. Anybody that do that, it's on its face. Now, you're entitled to your own opinion. Don't be swayed necessarily by other jurors. You're entitled to your own opinion. The law gives each one of you your own voice. Don't let other jurors bully you into a position that you don't feel comfortable with. Stand firm. And I'm not saying one way or the other, but you stand firm in your convicted beliefs. That is what the law requires, and that's what you should do. Again, you're a chosen jury. It's not random. You came here, that was random. But each one of you was chosen. I used 10 strikes. I think they used 8 strikes. We chose you for a reason. We chose you because we knew that you could be fair and impartial, that you would follow the law. It's an incredible responsibility that you have. It's not random. Each one of you were chosen for a reason. Read it to me. We've been sitting over there in the corner. I had to bring her right here in front of me. Look you in the eye. You heard from her daughter that she's a loving mother, that she was there for her family, that all this other stuff about dirty house and all this stuff that they try to say is the murder from that video, they threw in all this other stuff. Bed bugs, dirty house. Her daughter, the one that's there, the one that's a teacher, the one that's part of the pastoral part ever, married to a pastor, all the people here in attendance, saying exactly what you needed to hear, right? That the lady, that you saw how she acted, that she didn't pay rent, that she brought her boyfriend and kids in there and was dirty and messed up the house and she got kicked out. She had an axe to grind. But why present all that if this case isn't what it was supposed to be? The murders on video is what they're trying to say. They're trying to say it's so open and shut. And why are they adding all this other stuff in there? This is real. This is no high school debate. This is no roundtable discussion. This is this woman's life, this woman's freedom. And I'm not saying that she did everything right, because God knows it. I already said she did. And you can be angry in here at Reader, but you can't do it in there. Now, you've been given, as I said, an incredible responsibility, one that almost nobody has. You heard the judge tell you out of all the United States and the state of South Carolina, you were chosen. There's only 3 people I know that can judge another person. That awesome power of judging a person. That's you as jurors, the judge in the black robe, and the man upstairs. You have been given just an opportunity in your life, one that's the most difficult decision in life. I understand. We put you in a tough place. But it is an incredible responsibility. You're sitting in judgment of another person. There are no do-overs. You wake up tomorrow, you have your breakfast or your coffee. You think, did I make the right decision? It's too late. There are no do-overs. You can't wake up 10 years from now, 30 years from now, 50 years from now, wondering, did I make the right decision? There are no do-overs. If you have doubts, you have them now. You have them in that room. You be confident in your verdict. If you have any hesitation about hitting that guilty button, that's reasonable doubt. And that is not what you're supposed to do. Any hesitation, firmly convinced, the prayed heart, they had no belief that they put those kids in that car with that Christine in that car with that air gun. No belief. They firmly convinced it was the prayed heart. You got to be sold on that. I'll just end on this. There are no words. There are no excuses. Just the law and your sworn oath to find her not guilty of murder. They gave you the answer 3 years afterwards. Tell them what the answer is. Thank you.
Mr. Stone.
Thank you, sir. The defense wants you to believe that because they didn't get together and say, let's kill Christina, there's no malice. Unfortunately, that's not the law. That's not what the law is. That's not what the judge is going to tell you. The judge is going to tell you this. That malice can be inferred from conduct so reckless and wanton as to indicate a depravity of mind and a general disregard for human life.
And renewed objection.
It's not going to be,
Objection's overruled.
thank you, Your Honor. It's not going to be the malice that they're trying to say has to exist. They got together and said, let's kill Christina. The bottom of this, malice does not require ill will toward the individual. What does it require? Actions and conduct so reckless as to show a disregard for human life. So the question you have here is, what did they do to show a disregard for human life? And the answer is everything. Everything. You want to know what's relevant about the loaded gun in the back seat? That's a disregard for human life. As the first defense attorney got up there and said, everybody in South Carolina knows you put a child in a car that's in direct sunlight in August and you leave them there, they're going to die. Right. That is a disregard for human life. In fact, it would be actually better and easier if you went through and tried to find a sign at which time they actually showed you some regard for that child's human life. But you won't find it because it's not there. It's not there. Larry's defense attorney came up here and basically said this. Well, just like the solicitor said, he may have thought the air conditioner was on. Right. Because he was high. Because he was high. I don't know what he was thinking. I think if any of us watch this video, the one question that has to pop in your mind over and over and over again, what are you thinking? What are you doing? You put this child in the car, and you know nobody's been in the car. You know it's not on. There's no air conditioning. You're in the middle of summer. You're in South Carolina. Everybody knows you're not supposed to. What are you doing? What are you thinking when you find the child locked in the car at 3 o'clock that afternoon? 4 hours later. Let's don't break the window. Let's go find another key. What are you doing on the swings? What are you doing when you're going inside and having sex and the child is still out in the car cooking? What are you doing? And there's no answer to that. You know why? They're high. What the judge is also going to tell you is that voluntary intoxication, voluntary use of drugs is not a defense in South Carolina to anything. To anything. If they're high and they think the air conditioning's on, so what? They're high. And by the way, the disregard for the safety of others, the disregard for human life, I'm getting high to begin with. You go in to get your child. Continue to get high. Put the quick hit in the car while you're high. You can't find a single thing in this anywhere that shows that they care 1 ounce about that child. Did I say at the very beginning that that child was baggage? Child was baggage on that day. Did some witnesses take the witness stand and say, she's been a good mother in the past? But none of them knew about her nephews. None of them knew how she acted when she was high on Beth or Larry. None of them did. They didn't lie to you. They didn't know. And they said they didn't know. Larry says, okay, I got another defense. Not my child. Never mind, he put the child in the car himself. He wants to pass because it's not his child. He's not responsible for the child. Because he doesn't have any regard for human life, her child, or anybody else's. Supposedly, if I saw something going on with a child, I'd do something about it, would you? What about 3 o'clock in the afternoon? The child's locked in the car. Break the window. That's Larry. What about me? They made a big deal about Brittany Honeycutt. What did Brittany Honeycutt tell you? She said, take this child with you. Please take this child with you. I got to go to work. I can't take the child with me. Take her to work, put her in the car, leave her there. That's what I do. I do it all the time. They said, well, Brittany Honeycutt didn't like her very much, and she didn't like her. Okay, fine. Let's go to Lindsay Lewis, the babysitter. The same babysitter that Rita abandons her child with 3 days before this takes place. babysitter who'd never taken care of the child before, the babysitter who didn't even know that if the child ate solid food, that there was a choking hazard because Rita never told her. The same babysitter who came in and testified there wasn't any food in the house, and she just left. And all Saturday, I tried to call her, and she didn't respond. You know why she didn't respond? Because she was getting high with Larry. Her focus was on Larry. Her focus was on getting high with Larry, not anything to do with this child. She didn't respond then. She didn't respond before. She didn't respond for this entire event, not to that child. All of her concern is Larry. She abandons the child with the babysitter. Then she turns around and puts the child in the car. They don't forget it. Just like I said in my opening statement. They didn't forget her. They stood around the car until they went inside and had sex. Where was the child in the car? It's abandoned the child again. Yeah, I don't want the fact that I said baggage. It's exactly how they're treating that child. Baggage. In the way. Because she needed to be with Larry. She abandoned the child then. And the child's locked in the car. Does she stay with the child? No. She and Larry go and hug and kiss in the car in the truck and they take off. It's abandoned the child again. And one more thing, and I'll sit down. Mr. Phillips brought up an excellent point. He said he's a parent. Lots of his parents. When she finds that her child is dead, I'm a parent. Imagine finding my child dead.
Objection, Your Honor.
Just like Mr. Phillips said.
Objection is,
Speculation is improper. It's not in evidence.
the objection is overruled.
Thank you. And imagine. Most parents, they find their child dead. They're not going to be inside the house when the police get there. In fact, the police are going to have to pry the parent off of that child. And if the police don't have to do it, the coroner's going to have to do it. The coroner's going to have to do it. The funeral director's going to have to do it. Because the parent's going to stay with that child. That child is dead. The child is part of them. They're never going to leave that child, even if the child is dead. And what did she do? She went inside. She abandoned the child. Maybe at some point in her life, maybe on other days, she would have done that. But on August 5th, 2019, two people found that murdered that child. On this day, they tortured that child.
Madam Forelady
Yes, sir.
and members of the jury, you have heard the testimony, received the evidence, and heard the arguments of the state and the defendants. I will now explain to you the law that applies to this case. Under the Constitution and laws of the state of South Carolina, you are the finders of the facts. I do not have the right to pass on the facts or to express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine. As jurors, then, it is your duty to determine the effect, the value, the weight, and the weight of the evidence presented during this trial. As a trial judge, it is my responsibility to preside over the trial of the case, to rule upon the admissibility of the evidence offered during the trial. You are to consider only the testimony from this witness stand, together with any exhibits which have been made a part of the record. I have the additional duty to charge you the law applicable, and as the presiding judge, I am the sole judge of the law. It is your duty as jurors to accept and apply the law as I now stated to you. Then deliberate in an effort to reach a verdict. I charge you in that regard that you should not be concerned with what you think the law ought to be, but what I tell you that the law is. Now you are also the judges, the sole judges of the credibility, that is the believability of the witnesses who've testified and of the evidence offered during the trial. In considering credibility, you may take into consideration many things, such as the demeanor or manner of testifying, whether the witness had reason to be biased or prejudiced, and whether the testimony of a witness was contradicted on the one hand or supported and corroborated on the other hand. You may believe a small portion of a witness's testimony and disregard the larger, or vice versa. These things you will consider, bearing in mind that you should give each defendant the benefit of any reasonable doubt. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by direct evidence or circumstantial evidence. The law makes no distinction between the weight or the value to be given either direct evidence or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray a defendant's behavior as suspicious, the proof has failed. The state has the burden of proving each defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. Now, the rules of evidence ordinarily do not permit witnesses to testify as to opinions or conclusions. An exception to this rule exists for witnesses who are called expert witnesses. An expert witness is a witness who, by education, experience, has become an expert in some field. And that witness may state an opinion to relevant and material matter within their expertise. And they may also state the reasons for their opinion. You should consider any expert opinion received in evidence, and like any other evidence, give it the weight that you think it deserves. If you decide that an opinion of an expert is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of any other witness, simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it is not contradicted. Now, I instruct you and emphasize that the fact that a defendant did not testify is not a factor to be considered by you in any way in your deliberations and in your consideration on the question of the guilt or innocence of a defendant. It must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. So I repeat, under your oath, you are to draw no conclusions whatsoever from the fact that a defendant did not testify. The fact that a defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated, is on the state. The defendant is not required to prove him or her innocent. The burden remains on the state to prove guilt beyond a reasonable doubt. Now, the fact that the defendants were arrested, charged, and indicted is not evidence and cannot be considered by you as evidence of guilt, nor does an indictment create any presumption or inference of guilt. The indictments are simply the formal written instruments which contain the charges made against the defendants. The indictments are the formal documents by which this case is brought into this court. Each defendant has pled not guilty to the charges in the indictments. And those pleas put the burden on the state to prove the defendant or defendants guilty. A person charged with committing a criminal offense in the state of South Carolina is never required to prove himself or herself innocent. I charge you that it is an important rule of the law that a defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies each defendant throughout the trial until you reach a verdict of guilt, satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of a defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It's not just a legal phrase. It is a substantial right to which every defendant is entitled, unless you are satisfied from the evidence of proof beyond a reasonable doubt. The state has the burden of establishing every fact necessary to prove each defendant guilty beyond a reasonable doubt, because the law presumes every defendant charged with a crime to be innocent, and the burden of establishing guilt is placed solely on the state. So what is a reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. Proof beyond a reasonable doubt, therefore, is proof that leaves you firmly convinced of the guilt of a defendant. There are very few things in this world that we know with absolute certainty, And in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are convinced that a defendant is guilty, then you must find him or her guilty. If, on the other hand, you think that there is a reasonable possibility, a real possibility, that either or both of the defendants are not guilty, then you must give each of them the benefit of the doubt and find him or her not guilty. The indictments in this case allege 3 separate offenses against each defendant. The indictments are murder of Christina Pangalangan, great bodily injury on a child, and criminal conspiracy. Each indictment charges a separate and distinct offense as to each defendant. You must decide each indictment separately on the law and the evidence applicable to it, uninfluenced by your decision as to any other indictment. Each defendant may be convicted or acquitted on any or all of the offenses charged, and you will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant Rita Pangalangan and the defendant Larry Eugene King are charged with the murder of Christina Pangalangan. The state must prove beyond a reasonable doubt that the defendant or defendants killed Christina Pangalangan with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant or defendants just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which expresses hatred or ill will for another, or when the person prepared beforehand to do the act which was later committed. Malice may be inferred from conduct showing a total disregard for human life. Malice may be inferred from conduct that is so extremely reckless and wanton as to indicate a depravity of mind and general disregard for human life. In the context of murder, malice does not require ill will toward the individual injured, but rather it signifies a general malignant extreme recklessness of the lives and safety of others, or a condition of mind that shows a heart regardless of social duty and fatally bent on mischief. As to the charge of great bodily injury on a child, the state must prove beyond a reasonable doubt that the defendant or defendants inflicted great bodily injury on a child. Great bodily injury means bodily injury which creates a substantial risk of death or which causes serious injury or permanent disfigurement or protracted loss or impairment of a bodily function, member, or organ. As to criminal conspiracy, the state must prove beyond a reasonable doubt that the defendants combined together for the purpose of accomplishing a criminal or unlawful object or an object neither criminal nor unlawful by criminal or unlawful means to establish the existence of a conspiracy. Proof of an express agreement is not necessary, and direct evidence is not essential, but the conspiracy may be sufficiently shown by circumstantial evidence and the conduct of the parties. Now, in order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, extreme recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. And criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says criminal intent may be shown from circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established in the same way as any other fact by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant or defendants intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or failure to act. It may arise from negligence, extreme recklessness, or an indifference to duty or to consequences that is considered by the law to be an equivalent to criminal intent. Voluntary intoxication or use of drugs does not constitute a defense to a crime, but proof of mere presence at the scene of a crime is not sufficient to find someone guilty. However, The law also says that the hand of one is the hand of all. If a crime is committed by two or more persons who are acting together in the commission of a crime, then the act of one is the act of both. When a person does an act in the presence of and with the assistance of another, the act is done by both. As indicated, mere suspicion, however strong, is not sufficient to sustain a conviction. Suspicion implies a belief or opinion as to guilt based on facts and circumstances which do not amount to proof. Now, while the arguments of counsel are a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting their arguments, counsel often refer to the evidence. However, you should base your verdict on the evidence as you remember it. If there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely on your own understanding of the evidence. In matter 480, members of the jury, I'm required to charge you the law as I've done through giving you these instructions, and that's to help guide you to a just and lawful verdict. Whether some of these instructions apply will depend upon what you find to be the facts. The fact that I've instructed you on various subjects must not be considered as indicating an opinion that I have as to what you should find to be the facts or what your verdict should be. Now, you've been chosen and sworn to give the parties a fair and impartial trial. When you've done so, you will have complied with your oath, and no one will have a right to criticize your verdict. You must not be influenced by opinions or expressions of opinions you may have heard outside of the courtroom, but rather should base your verdict solely on the testimony of the sworn witnesses who took the stand, the exhibits received into evidence, and the law which I have stated. You should not be swayed by caprice, passion, prejudice, or improper sympathy for or against anyone. Remember, you have no friends to reward or enemies to punish, and all parties are entitled to a fair and impartial trial. It is your duty as jurors to consult with one another and to deliberate in an effort to reach an agreement. Each of you must decide this case for yourself, but only after an impartial consideration of all of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and to change your opinion if you become convinced that it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I stated earlier, you are the judges of the facts. Your verdict must represent the considered judgment of each juror. In other words, your verdict must be unanimous. In matter 480, it will be your duty to preside over the deliberations of the jury. If during your deliberations you should desire to communicate with me, Please reduce your message or question to writing, signed by your foreperson and the foreperson only. Then pass the note to the bailiff, who will bring it to my attention. I will then respond as promptly as possible, either in writing or to have you return to the courtroom. However, I caution you, however, with regard to any message or question, that you should never state or specify your numerical division at the time. You've heard the evidence, and now you have heard the law. Whatever your verdict, Madam Forelady, you will indicate the verdict on the verdict form. And we have two verdict forms, one for Pangalangan and one for King. And as to each charge, the verdict is either not guilty or guilty. You would check the appropriate box, then sign it at the end. Now remember that although only the foreperson writes the verdict, it is not hers alone. The verdict has to be unanimous. And Madam Forelady, you're not authorized to write the verdict until all of you have to have agreed on the verdict. So ladies and gentlemen, I'm going to send you to the jury room to start deliberating in a moment. But when you get there, don't begin deliberations until you've received a copy, until you receive the copy of the verdict forms and the exhibits. And once you receive these things, that will be your signal to begin your deliberations. Once you begin your deliberations, you will deliberate until you have reached a verdict, at which time you will knock on the door, advise the bailiffs, and we will bring you out to receive your verdict. Now, we've selected 14 people to serve on jury duty. First 12 regular jurors and then 2 alternates. Before asking any question about whether you can continue with the deliberations, want to inquire of the jury whether anyone has made an effort to contact you about the case, or whether you've viewed any media articles or been otherwise exposed to any other information about this case other than what you received in the courtroom. If you've seen or heard anything else outside of the courtroom or been contacted by anyone concerning the case, if so, raise your hands. And no hands are raised. Now, if we have 2 alternates, 2 very capable alternates over there, if for any reason any of the first 12 of you selected cannot continue with deliberations, please raise your hands. So all the first 12 jurors are good to go, which means that the 2 alternates will not be able to participate in the deliberations. And when they go to the jury, if you all will hold your position right there. So I'm going to send you to the jury room now and wait for the verdict form and the exhibits, and that will be your signal to begin your deliberations. So please go to the jury room. Will they close the door? Is that door closed? Are there any additions or exceptions to the charge?
No, sir, none from the state. None, Your Honor. Thank you. None from the charge, Your Honor. Whenever the appropriate time is, as a matter of law, hearing, closing, you can put that.
All right. So if you all then can review the exhibits that's going back to the jury along with, we're going to pass up the verdict form to them as well.
Does Your Honor send the indictments back or just the jury?
No.
Woo-wee. They are praying hard, are they not? Hang on, what the hell is going on here? Look at that. She's got the hands clasped. He's sweating bullets. Looks like he could bite through nails. Slim said, I have no idea where my question went. I think this judge is extremely fair. And I think he is brass tacks. And I like how he explains things to the jury in language that OJ can understand. Yes, we have a poll. When Muscles runs for president, will you run for her? And I love watching our system work. We don't live in foreign countries where you can just look at someone wrong and they put you in jail. Makes me sick sometimes when they're walking around living their best damn life and we all have to grin and bear it. But it's exactly what happens. It is. But I just absolutely love watching it unfold. mistrial, the judge overruled it. They're going to go back and forth and back and forth and back and forth because he's going to want to go home, like most judges, sometime tonight. Sometime tonight. You know, he's got Labor Day weekend too. And he already judge-splained everything to the jury. So did they intentionally leave her in the car? Yes or no? Did they have conspiracy to put her in the car? Yes or no? Did they do everything in their power to get her out? Yes or no? There's a lot going on here. So they're going to have to sort through all of this. But the mistrial makes zero sense to me. But we are officially on verdict watch. If anyone hears that the verdict is in, because I am not always online, most of you have my phone number. You have some way to get a hold of me. Let me know, and we will come on because I am really wanting to see this. If the verdict doesn't come in today and we can't cover it, then we will be back here on Monday for a members live. And if I miss you on the members live, then we'll be back on Tuesday because I really want to recover this case. I want to go right back through it because it is one insane case. And it's something that should have never happened. So we could be back in 30 minutes. We could be back in an hour. It's 3 o'clock South Carolina time, 3:05. So we'll see. We shall see. But in the meantime, thank you for being here. And we will see what happens. You guys are the absolute best. Thank you for being here. Me love you long time.